The problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. Yeah. And I know I'm talking in legalese and I'm trying not to. Okay. A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted.
This case opens with tension already baked in. No settlement, no compromise, and two sides who clearly don't see reality the same way. What makes this hearing fascinating isn't explosive testimony or dramatic outbursts. It's something far more dangerous in court: procedure. Because today, this isn't just about rent, deposits, or damages. It's about whether the plaintiff even followed the rules required to bring those claims in the first place. And once a case shifts from facts to procedure, the balance of power changes instantly. Judges stop weighing fairness and start enforcing structure. Watch closely, because Judge Simpson is about to walk a tightrope, trying to keep the case alive while making it crystal clear that courtroom rules aren't optional. The real question is, did the plaintiff fatally damage their own case before trial even begins?
Your names?
Travis Hawkins.
All right. You folks tried to resolve this matter or no? We're just going to go to trial. Pardon?
We attempted this weekend, and we did not come to a resolution.
How close were the parties before we go into this?
Not very close, sir.
Mr. Ellis, you'd agree with that?
Yes, Your Honor. The defendants do not feel that they owe any money.
All right. You sent something to Miss Loudon. She's right now doing that.
I'm sorry.
She's doing that right now. You did?
I'm doing it right.
Okay. On the Lewis Loudon matter, I'm only because she was here the last time, seemed rather intent on proceeding with the case. And I think it indicated she was going to get an attorney and do some other things. I'm going to try to, we checked the courtroom, see she's not there. I'm going to try to send an email and to her, and I'll ask your patience. I'm going to do that because of an email that she sent regarding certain medical issues. So it'll be just a minute, but I won't hold you guys very long. Is that okay, Miss Barton?
Absolutely, Your Honor. Absolutely.
Wow, what happened? She must have had a good holiday.
It's always a pleasure to be.
Yeah, I don't know. That's not. Check her ID. That's not Miss Barton. Okay. On this matter, then, this is the date and time set for trial on the Seminole matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages, and I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
It was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to. It may have been filed in Saline. I need to reach out to obtain a copy.
Hmm?
Do you need me to reach out to obtain a copy?
I've got one in front of me. When did you guys get a copy of this?
It was dated May 21st, 2024.
So a few days
A
after
few
that.
days after that,
And what?
just before heading into Memorial Day weekend. This-
21st?
Yeah, this was dated May 21st.
For what date did you, the postmark? What is that?
Postmark on May 21st, right here is the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
Right here is where this case quietly pivots from a dispute about money to a dispute about timing. And that's a huge deal in civil court. Judge Simpson isn't debating whether the plaintiff might eventually be right about the security deposit. He's laser focused on when that claim appeared and whether the defendants were given a fair chance to respond. Courts are obsessed with notice and opportunity. Both sides must know the claims against them early enough to prepare a defense. And what's happening here suggests the plaintiff introduced new allegations dangerously late. That triggers procedural red flags immediately. So even if the plaintiff has a valid argument buried somewhere in this complaint, introducing it at the 11th hour can make it legally unusable. That's the paradox of litigation. Substance matters, but timing can kill substance before it's ever heard.
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
That is exactly what, is that what you said?
Yes, sir.
Your Honor,
No, I don't, just answer my question.
yes, yes, sir.
This exchange is subtle but incredibly revealing about courtroom dynamics. When Judge Simpson says, "If you're telling me my recollection is incorrect, you're wrong," he's not just asserting memory. He's asserting judicial authority over the factual record of prior proceedings. Judges rely heavily on what was said in earlier hearings, and disputing that recollection without proof is risky territory for any attorney or party. It signals to the court that you may not fully grasp how procedural history works. And notice the judge's core point. The forwarding address issue isn't just factual. It's an essential legal element of any security deposit claim. Without properly alleging it, the claim itself may collapse. So this moment isn't about disagreement. It's about whether the plaintiff's pleadings even contain the legal ingredients required to exist. And right now, Judge Simpson is signaling they probably don't.
That's exactly what they said.
they did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree. That's fine. But that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem. It's been pending. They're entitled to answer, first of all, the motion to amend. And this is the procedural problem. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it. It says on the 17th. They don't get it till then. So they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I've answered it, sir.
That was an unfair question. Um, Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see it, the numbers that are there? All right. Without telling me why, because you don't, I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no collection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Stemmer back for that.
Okay, but
We won't
let me,
I don't have a problem disputing that.
pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not
have no problem with that
It's fine.
amount? Okay,
every year.
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes, sir.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court. And they never answered the complaint.
So the landlord tenant proceeding, they can answer orally.
This is one of those courtroom moments that feels small, but carries massive implications. The plaintiff essentially argues they had an absolute right to amend because the defendants never filed a formal answer. And Judge Simpson's reaction, geez, know the procedure before we walk in, tells you everything. Landlord-tenant courts often allow oral answers, meaning silence on paper doesn't equal default. That misunderstanding alone can derail strategy. What we're seeing here is a classic pro se litigant trap, assuming civil procedure works like everyday logic. But courts run on technical frameworks, filing methods, timing rules, pleading standards. Miss one, and your claim can collapse regardless of merit. Notice, too, that the judge immediately pivots to accommodations about hearing equipment. That's judicial balance again, correcting legal error firmly while still ensuring the party can participate fairly. Authority and fairness, side by side.
Jeez, oh Pete. Know the procedure before you walk in, counsel. Court's going to stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Court recalls the case of Samanek versus Okerman and Meltzer. All right. Couple of things here. First thing is the motion filed before the court is, I'll say it this way. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint, mainly because it changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it, however it gets resolved through trial, right? Having said that, the other problem then arises. So let me back up a second. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer, which I would grant the motion. So let me make it easy. All right. So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint. Okay. And basically, it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. Yeah. And I know I'm talking in legalese and I'm trying not to. Okay. A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted. The remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit when a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. All right. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days. Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint. Bless you. Within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff. 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Oh. Then adjourn the non-jury trial to, will that give me enough time? What's today? I didn't count out my days. Today's 28. 10. The 17th. And then we have the 18th. 9 a.m. All right. Then I'll adjourn non-jury trial to, well, on the way out the last time, my understanding is there are nuptials that are to be occurring. So,
Yeah, Brian Michelle is next one, and a bachelorette party.
I don't want to know about a bachelorette party, but go ahead. What? So, if I set it for June 18th, is that going to interfere with what you have? I mean, outside the stresses of everything.
The 21st of June. And I have to be in.
I'll have you out by then. What?
I have to be in Indiana. So I'll be traveling,
It's
but
not that far.
yeah.
Well, will you be traveling? Can you do the 18th and then
Yeah, I'll make
still
it.
get, you'll do it? Okay.
Yeah, I'll make it.
So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does that. Till 1 o'clock. All right. So court stands in recess.
What Judge Simpson ultimately does here is a masterclass in procedural fairness. He recognizes the plaintiff's filing is flawed, missing required elements under the Security Deposit Act, and vulnerable to dismissal. But instead of shutting the case down, he gives structured guidance. File a proper amended complaint within 10 days, include the legally necessary allegations, and allow the defendants time to answer. That preserves both sides' rights while protecting the court's standards. The takeaway is powerful. In civil litigation, you don't just need facts. You need correctly constructed claims delivered at the right time. Procedure isn't paperwork trivia. It determines whether your argument even exists in the eyes of the law. So now the case moves toward trial with a reset clock and clear instructions. The real question moving forward is whether the plaintiff can fix the defects before June 18th, or whether procedural missteps will continue to haunt this case. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.